Hi there. Good afternoon, everybody. My name is Chris Justice, and I'm an employment lawyer, as you see down below there, with Samfiru Tumarkin. And as always, I'm here to hopefully answer as many questions as I can, all things related to employment law. So if you've got a question about maybe a contract that's been put in front of you, maybe you've just lost your job and you're wondering sort of what your options are in that case, or perhaps you're just going through something in the workplace that's problematic and you're looking for some answers to some questions you may have. Again, whatever it is, do your best to get your questions in this afternoon, and I'll do my best to answer as many as I can, as I always do. But before we get into some of the questions, as I normally do, I like to sort of bring up maybe a case of the day or some news of the week. This time around, one of the things I just wanted to talk about, and for those out there, you may have heard this before, but there are a lot of layoffs going on. A lot of layoffs in various different industries. We're hearing about people getting let go from BMO, from eBay, Panasonic, EA. So tons of companies doing a lot of restructuring, shifting, and that is resulting in a lot of people being laid off. So I wanted to kind of break down some of the basics around layoffs and what you should be looking for. So the first thing, though, is what is a layoff? That term I think is used relatively loosely. There's basically two different forms or versions of layoffs. One is going to be your more temporary layoff. So, the company comes to you and says, we're not letting you go permanently, but we're laying you off for a certain period of time or an unknown period of time, and we're trying to call you back. And so they're basically telling you that you haven't been let go, you're maybe called back later, but you're not going to be working from this point moving forward until we tell you. And then there's the more permanent sort of quote unquote layoff, which is essentially a termination. And that's where it's not a temporary thing. They just come to you and they say, today's your last day, or maybe, 2 weeks or 3 or 4 weeks from now, you're no longer going to be with us and we're ending your employment. It's just the word layoff tends to get used interchangeably. But whether you are someone in a situation that's subject to a temporary layoff or a permanent layoff, in other words, a termination, in the eyes of the law, whether it's temporary or permanent, it's going to generally still be seen as a termination of your employment. Now, obviously, if it's a permanent layoff, that makes sense. But the reason why a temporary layoff is considered a termination is because it represents a significant change to the terms of your employment in a lot of cases. Even if you're being told the hope is that we're going to call you back to work, the fact is that you may not be called back, number one. But secondly, even if you are called back, you're still without a job, you're still without an income, a wage for potentially several months. And so even though they may intend on calling you back, to reduce your wage from whatever it is you were making to now $0, even if it is for a number of months and not indefinitely, that's still a significant change to the terms of your employment. And it's not a change that you necessarily need to just accept and just say it is what it is and hope to get called back. You actually may have the option to treat, like I say, that layoff, even if it's temporary, as a termination and go after the company or pursue your full severance from that company. Now, in the case of a permanent layoff, again, more clear cut, the question is usually going to be, how much severance are you owed? In the case of a temporary layoff, same question gets asked, but there are a couple situations where companies can sort of, for lack of a better phrase, get away with it. So in a case of a temporary layoff, if you have been laid off in the past before, if you've accepted temporary layoffs in the past before, and this maybe newest layoff is the second or third or fourth layoff that's been implemented, there's an argument that can be made that the company has the right to lay you off for another time because of the fact that there is a history to this happening before. So it's not going to be necessarily seen as a significant change to your employment, the temporary layoff that is, if you have agreed and consented to previous layoffs in the past. So that's one thing you want to be mindful of. Nothing I say is makes it black or white. So even if there is maybe a previous layoff that you had, it's not to say that no matter how many other layoffs they put in place, they can do so. But creating a pattern or there being a history of layoffs can certainly help the company in trying to argue that they have the right to do that. If you don't have a layoff ever before, if that has never happened in your employment with this company before, and now this temporary layoff is the first one that's ever occurred, then again, that's going to be a feather in your cap, and the company is going to be hard pressed to make that same argument. So assuming that's not on the table in terms of there being a history of layoffs, there's only one other main instance where companies can temporarily lay somebody off, and that is if they just consent to it. So that could be you have a discussion with your employer, you say, that's fine, I'm okay with being laid off, just call me back ASAP. That may signify your consent. Or you may have signed a contract, maybe when you were hired, maybe at some point after you were hired, and you look at the contract and there may be a section in there that talks about temporary layoffs. So it may say something along the lines of, if the company does decide to lay you off on a temporary basis, it may do so, and you agree that this is not a significant change to your employment or what's otherwise often known as a constructive dismissal. So you want to check back on your contracts as well, just to see if there's anything around layoffs there. If there's nothing in your contract that talks about layoffs or layoffs being a possibility, and you haven't agreed to any previous layoffs before outside of that, then again, you're going to be in a situation where you don't have to necessarily wait around to see if the company is going to call you back. And you do have the option of saying, this is unacceptable. I'm not consenting to this. Now I'm without pay for an unknown period of time. And basically, I want my severance. So regardless of which situation you're in, a lot of these cases do result in a termination in the eyes of the law. It's not so much what your employer thinks is the case or what you think is the case. It's just generally how the law interprets it and views that. And so if you are in this situation, if you're laid off permanently or temporarily, and it is a termination in the eyes of the law, then you're going to be potentially pursuing your severance package. And so that severance is going to be based on just how long you've been at the company. It's going to be based on the position that you had with the company, the age that you were at the time they laid you off. And these are all going to be the main factors going towards calculating how much severance is owed. And for those out there that don't know, if you've been laid off, your potential severance entitlements could be as much as 2 years. So it's definitely not something you want to treat lightly, and you don't want to leave any stone unturned. Always recommended that you get in touch with us, regardless of what the situation is, temporary or permanent. And then that way we can set up a consultation with you so we can kind of go through the factors at play, what severance you're owed, how good of a chance you have at getting that severance, what may be required, whether it's negotiations to try to avoid litigation, or whether it actually means needing to get into litigation, into the lawsuit to pursue what's rightfully yours. And so you want to make sure when you're doing that you're also getting a fulsome severance package. So if somebody lays you off and says, we're going to give you 6 months of your base pay and 6 months of benefits, but then they don't mention anything about maybe the commissions that you're owed or the bonuses that you would normally get. There could be other items of your overall compensation package that sort of are omitted or not included in the severance offer. So even if the number of weeks or the number of months being offered to you is relatively reasonable or within the range, there could still be missing pieces that can add up to thousands, if not tens of thousands of dollars. So that's another thing to keep in mind, to make sure that not only that the company is giving you the correct number of weeks or months of severance, but that they're giving you a fulsome number of weeks or months that includes, if you can, all aspects of your compensation, all aspects of your remuneration. So that's another thing to kind of keep a mind's eye on. So just to kind of recap, though, if you're in a layoff position, temporary or permanent, don't sign anything immediately. Get some legal advice first. Preferably if you can get the reason for the layoff or the termination put in writing. Always a good idea to ask the company to put that in writing. Make sure that you have any employment contract that you may have signed or various contracts you may have signed throughout the years you were there. handy so that the lawyer that's dealing with you can kind of look over that. You want to consider as well potentially applying for employment insurance, EI benefits, because in a lot of cases you are going to be eligible. And that can also provide some income in the meantime while you're potentially having to negotiate with the employer. And as I say, just ultimately have that severance offer reviewed with a lawyer before accepting it. Because in most cases, whatever is being offered to you, especially in the first part of things, is going to be on the low end. It may look like it is a reasonable or fair package, and you may think that no problem, I'll sign off on the dotted line so I can get the money. But even if it looks on its face reasonable, as I say, in most cases, if not all, there's still movement to come. These things are still normally negotiable. The company is sort of half expecting you to come back, or a lawyer on your behalf to come back and try to negotiate a better package. So yeah, that's kind of a little primer on layoffs, whether it be temporary, permanent, and sort of what steps you need to engage in moving forward to make sure that your rights are protected. I have some other topics that I was going to get into, but I do want to answer some questions before I do that. That's first and foremost. So I've got a question from Herc on Facebook who's saying, we're asking whether my employer can prohibit me from taking a sick day during a 90-day probation period. And the general answer to that is no, especially if it's obviously a legitimate reason for needing the day off. And especially if you've got a sick note from your doctor, these things should be acknowledged, adhered to. If a company pushes back and basically prevents or refuses to give you a sick day or time off to recuperate from whatever is affecting you, then they run the risk of not accommodating your needs from a human rights perspective, from a disability or an illness perspective, and they can actually be in hot water. It doesn't matter if you're asking for a sick day in your first week or your first year, your first decade. The same general principles apply. So I'm not sure on what grounds an employer would sort of prohibit or refuse to allow somebody off for illness or sickness. Maybe there's something more there to it, but on the face of it, that wouldn't be something normally allowed. And like I say, the employer could get into hot water by sort of continuing to go down that path of refusing to accommodate the situation. I've got another question in from Alicia, who's saying that they're on maternity leave. Their original return to the workplace was the end of March, but the doctor wants them to stay off work a little while longer for medical reasons. And the company is saying, I don't think we can wait. We can't wait around for you. We don't really want to wait around. Again, this is another situation where there could be an argument that the employer is failing to accommodate a situation, a health-related situation. If the doctor is recommending that you stay off work a little while longer for medical reasons, and especially, again, if you've got a note from the doctor saying that your leave needs to be extended, whether it's to do with the fact of you going off on the maternity leave or for other medical reasons, maybe unrelated, either way, the company still has to make best efforts to try to accommodate, even if they think it's a burden or an inconvenience. They don't really want to do it. That's not generally going to be enough for a company to refrain from their obligations otherwise. And the question may also be, how much longer are you waiting, or are they waiting? But even still, even if you need months or potentially longer, again, all based on legitimate medical grounds, the company can't just simply say, well, you've got to come back, and if you don't come back, we're going to consider you to have quit your job. Because if that happens, then that is essentially tantamount to a termination. You would be looking for your severance in cases like that. And not only that, but of course, the company runs the risk of getting involved in a human rights case, a human rights violation. So it's not a matter of them being inconvenienced. They would have to show that there would be so much hardship suffered or faced by the company in granting this, that the sort of the cost, so to speak, outweighs greatly the gain or the idea of someone remaining off work. Now, Alicia, I would say you should contact us, though, just because sometimes there are some more particular pieces of information But from the sounds of it, on the basis of what you're saying, it just seems to me like an employer not wanting to do what it needs to do because it somehow inconveniences them. But you're, on the other hand, saying, well, I have legitimate reasons. This is what my doctor's suggesting. So I think you should definitely give us a call. We can sort of ask you to provide the proper documents or whatever we need in advance of the consultation so that we can give you the best advice. But yeah, there could be a problem. Hopefully we can resolve it without too much hassle. I've got another question in from James, who's asking, if you qualify for statutory severance pay under the ESA, which is the Employment Standards Act, does that increase your overall severance entitlement or just raise your minimum severance floor? So that's a good question, because there is sort of two aspects to the law. You've got the ESA on the one hand, that does represent your floor, your bare minimums. So depending on how long you're there, depending on the payroll size of the company, the ESA is going to say you're owed X number of weeks statutorily in terms of severance and notice pay. And then on the other side, you've got the common law. That is sort of the ceiling. That's the maximum severance you can get. So while the ESA does give you something, it just kind of gives you those bare minimums. But it's going to be up to you and whoever is representing you on your behalf to get, not just the bare minimums, but as much as possible, and ideally the maximums. The maximums in terms of your entitlement to the ceiling as opposed to the floor, that's based on the common law, or what's known as the common law, judge sort of created law, case law over the many years. And so that's where factors like, how long you were there for, your age, your position, how long you're actually unemployed for, these are all going to be considered when determining what your ceiling is. Now, let's say somebody's owed 12 months as their ceiling, but under the ESA, they're only owed 2 months, just as an example. You're going to be guaranteed those 2 months. If your employer pays you those 2 months, which it should, and your ceiling is 12, then the idea is you're basically trying to get that extra 10. So whatever you get paid under the ESA in terms of severance or notice, whatever that sort of floor is, that's going to be ultimately deducted from whatever your maximum entitlement is. So then you're sort of back to looking at that difference. It doesn't, severance pay doesn't increase the ceiling, so to speak, directly anyways. It's more so the floor. But again, the ESA is just the tip of the iceberg. So you want to make sure that you're getting, in most cases, much more than whatever the ESA says, because a lot of times the common law is often 2, 3, 4, 5 times as big as the ESA. So hopefully that answers your question, James, but thank you for that. I've got another question from Shan, who's asking whether their employer can force them to work from home permanently. They work for, looks like a telecom company. They've never worked from home, and they don't have the appropriate space in their house for doing the job. So I guess one question I would have is, why are they trying to force you to work from home permanently? That would be number one. But if you've never worked from home and it's not in your contract that it's a remote position, and you're saying you're not even set up to work from home, or that's not something that you can accommodate, because there are, I guess, situations where maybe if the company were to provide you with a laptop or a desk and a chair or whatever you need to get set up at your home, and you're on board with that, then that's one thing. Maybe something can be worked out. But if it's not something that's possible, and if you haven't otherwise agreed, whether it's in writing or verbally, to working from home, then the idea would be, well, no, I signed up for a job where I go into the office Monday to Friday and I work, let's say 9 to 5. That's what I signed up to do. I didn't sign up for a remote position. So for you then to come to me and say, we want to make it remote, as much as a lot of people may think that's more convenient, in some cases it's not. And if it's ultimately not something you've agreed to before, then it just seems like a scenario where the company is trying to push a term of employment on you that was never agreed to or consented to or signed off on. It's the same thing on the inverse, where somebody maybe has a remote position, but now they're being told or trying to be forced to go back into the office. If you haven't consented to it or agreed to it, for an employer just to insist on it happening is essentially them breaching the contract that you two have together, which is either to work from home or not, depending on the position. So normally I would tell people, I don't agree to working from home if that's not the case. I haven't signed anything to my knowledge that allows the company to do this. I'm ready, willing, and able to go into the office as I always have been, working, Monday to Friday, whatever it is. And that's what I'm willing to do. And you kind of just let your position be known that you're not quitting, you're not leaving, you're happy to do what you've been doing. It's just that you're drawing a line in the sand when it comes to them changing around the terms of your employment, whether it's remote or otherwise. If you said that and you made your position clear and the employer is still saying, no, it's our way or the highway, well, then they're going to be at risk of having to pay you severance. Because it is possible for a company to say, well, you know what, I get it. It's not a remote position, but we really want you to work remotely. You're saying, no, I want to come into the office. So we understand there's a difference here. So we're going to let you go. They can do that. There's nothing illegal with them doing that if they choose to let you go as a result of this sort of impasse that there is between the two of you. But then that's going to obviously obligate them to pay your full severance. Sometimes they don't go down that path and they just make it seem like, okay, if you don't work from home remotely, we're going to consider you to have quit, or we're going to consider you to have abandoned your job or refusing instructions. Maybe they claim that you're insubordinate for refusing all of this. And so we're just going to cut off your pay. Well, if they do that, then again, they would still owe you the severance because that's still a termination. But even more so, they could be on the hook for bad faith damages if they kind of continue to go down that path and just try to twist your arm in hopes that you accept it. So I do think you have options from the sounds of it. But again, like the others, happy to have a consult set up, happy to have you call in and we can get you hooked up with a lawyer who can kind of go through everything and just at least lay out your options so that if I go down this path, what am I looking at? If I go down that path, what am I looking at? But thank you for your question. I've got another one in from Frida, who's saying that they're on salary 40 hours a week and they get deducted time for leaving a doctor's appointment. They try to take them at the end of the day, so they only miss 1 or 2 hours. Is this normal? I've always been on salary and I've never experienced this before working here. So there could be an issue there for sure, for the company that is. If you are a salaried employee, you work 40 hours a week, let's just say you get $50,000 of salary and you do still need to take the odd time or 2 or 3 off to attend a doctor's appointment and they dock you pay, that can be a breach of the terms of your employment. That can be specifically a breach of the compensation terms of your employment. And not only that, but you could argue that you're almost being penalized or punished for having to get legitimate help or treatment from a doctor or a treatment team. Then that kicks into the equation potential human rights violations. So no, I wouldn't say it's normal. It could very well be the case that there's an issue here. It could be the case that you have the opportunity to essentially treat what's happening to you in terms of what the employer is doing by deducting pay as a termination, potentially as well as a human rights violation. So there could be something there as well, Frida. Again, like the others, definitely recommend you give us a call so we can kind of talk you through it some more. I've got another one in question from Sitting Knitter, who's saying that their employer let them go, stating that there was a lack of work, but I found out that they're just replacing me with junior for less pay. Is this a wrongful termination? So this happens a lot, probably more than it should, in terms of companies giving sort of a reason for why they let you go, but then it doesn't quite check out when you find out about some things behind the scenes. Being told that there's a lack of work and then replacing you for less pay don't seem to be compatible on the face of it. It very well could be the case that the employer has lied or has not told the full truth, in terms of what they mean, I guess, by lack of work for you, but abundance of work for somebody else, or lack of work, more generally, in which case, I don't know if it would make much sense to then hire somebody else. But it is common where they let people go, replace them with someone who will accept less pay. As bad as it may seem in a lot of these cases, it's not necessarily illegal for an employer to do this. But when you bring up the phrase wrongful termination, that may not so much relate to the way in which this was handled, but certainly if you're let go and you're not offered a fair severance package, which frankly happens a lot, then that could be deemed a wrongful termination. So a wrongful termination could mean they didn't give me my proper severance. It could mean that I was let go and sort of let go on a human rights basis. It's a violation. And I also wasn't given my proper severance. So it can kind of relate to both the way it's carried out as well as what's given to you at the time. But I don't know if there's a whole lot you can do around the idea that they told you it's a lack of work and then hired someone for less pay. But not to say that you don't have a case. In fact, you probably still do. And I'd still recommend you give us a shout. Maybe we can kind of flesh out a bit more what the employer said when they mentioned lack of work, whether that's something that's actually been put in writing. Because, you know, even though it may not be illegal, there could be some extreme bad faith present. And there are cases where people have argued bad faith on the part of the employer, and that has led to additional damages on top of the severance pay. So definitely something to look into for sure. But I appreciate your question as well. I've got another one in from Chris, who's saying they work for a big corporation in Texas. There's mandatory overtime constantly. Is there any protection for workers to not accept this mandatory overtime without fear of being fired? So I'll just say, if you work for a corporation in Texas, I guess my question is there any connection to Canada, or is it just that you work for a US employer and you're working in the US? Because there's a completely different area of law that obviously applies to US as opposed to Canada. I will say, though, that if you work for a company in Canada or maybe you work out of Canada for a US company, then you could be still considered a Canadian employee, because it's usually wherever you're working, not so much where the company is located. But you're saying that there's mandatory overtime constantly. So it seems like there's been a history of a lot of overtime. I don't know how many years or months or weeks this has been going on where they've just consistently done overtime over and over and over again. But if you have in the past accepted that overtime, and let's just say you normally work 40 hours, but in reality, you've been doing 50 to 60 every week for a number of months or years, that could create an implied term of your employment with that company, such that they now expect you to work those extra hours. That's always the risk in terms of things like this, where you may sign up for something and then it evolves into something different, but then in good faith, you kind of go along with it. That, like I say, can create an expectation for the employer. So like if I signed up to do 40 hours a week, but then a year into my employment, they start giving me a bunch of overtime and I just end up working on average 60 hours a week, and that happens for a period of years, it's hard for me to go back to the 40-hour per week situation if 60 hours has sort of been the norm for a long time. But either way, if you're being told to take on overtime and you don't want to accept the overtime, I don't know if there's any way that you could then prevent the company from pulling the trigger on you and letting you go. Generally, companies can let you go at any time for almost any reason, as long as it's not outright discrimination or extreme bad faith. So that's, I think, always often a risk when you don't want to do something that the company's asking you to do. It's not to say that firing you is the best idea or the most sensible idea, but it's also not, in a lot of cases, illegal for them to do it. It just means that if they do it and they let you go, the only thing you can generally try to go after them for or hope for is to make sure, again, that your severance package is fulsome and covers everything adequately. But it kind of then does still depend on sort of the back and forth and how long this has been going on and maybe what your contract says. So maybe, if anything, something to kind of delve into a bit deeper on a consultation. But again, I appreciate your question. I'll take one more question, but that'll do it for my time today. So for those that I don't get around to, I apologize, but definitely tune in on another show. We've got these things going on all the time. So the last question for the day is from Michelle. She's saying that they've got a new manager who dislikes them. They're using performance issues from 3+ years ago to outline why they need to be demoted. Are they allowed to do this? So if the criticisms are legitimate, they can criticize you, they can subject you to performance review, etc. That's not normally a problem. If the issues are not legitimate or they're from so long ago, then there's an issue, right? So a lot of times you'll get criticized unfairly, and that could actually result in a termination or constructive dismissal for which you're owed money. Or they can bring up maybe legitimate issues, but issues that happened 3+ years ago. Very hard for them to do that, because why did you wait so long? You can't just sort of bring something up from 3 years ago. You more so would have had to have brought it up at the time and relied upon it at that time. It doesn't make much sense to use something that's that old if it's not really applicable to you right now. But more so than that, I mean, the idea of being demoted, if you have a job, you signed up to do a job, even if your performance is poor, even if there's valid criticisms, that doesn't give the employer the right to demote you. And it doesn't mean that you have to accept a demotion. There's a lot of times where someone doesn't do their job to the employer's satisfaction. And if anything, they'll either work with them to improve, or they'll let them go and just say, you're not working out, we're going in a different direction, you're not the right fit. And then you're going back to the idea of how much severance am I owed. But an employer can't use criticisms against you to force you into then accepting a demoted role without your consent. Again, it all usually comes back to consent. So if you don't consent to that, and they just insist on going down that path of demoting you, that can be a constructive dismissal, tantamount to a termination, and that can result in you being owed severance, plus potentially other things. But again, as I said before, give us a shout. We can flesh it out. And that'll do it, though, for my time today, everyone. Again, appreciate your questions. I realize there's a few that I didn't get around to. But for those that I didn't answer, again, down below there, you can join us for many more Q&As that happen. We've got one, in fact, tomorrow with Sefton. So he'll be online. He'll be able to answer any questions for those I didn't get around to. But I do appreciate everyone attending today. I hope you all have a great rest of your Monday. And thanks again for joining us. All the best. Do take care.